again and again, and when he started moving his vehicle. Cop suddenly starts yelling, "Stop!
Leave! That's the part. Stay! Hey! Stop! Stop! Get out the car! Get the car! Get out the car! Get out the car!
Cop pulls out the weapon aimed at a senior citizen and asks him to get out of the vehicle. Police in the United States of America have made it a habit to pull guns over law-abiding citizens just because
There's a moment in every encounter between police and citizens where the trajectory becomes locked in, where what could have been a conversation becomes a confrontation, where discretion gives way to compulsion and authority hardens into dominance. This case begins long before the weapons are drawn, long before the taser makes contact with an elderly man's face. It begins with a father pulling over on a winter road, watching his son interact with law enforcement, and making a decision that millions of Americans make every day: to wait, to observe, to be present. What happens next reveals something fundamental about how power operates in American policing, not through grand declarations of tyranny, but through incremental assertions of control, each one defended as necessary, each one building toward consequences that no single officer intended, but all of them enabled. The encounter starts with the deputy conducting a traffic stop. Nathan Espinosa has been pulled over, reportedly for following too closely on icy roads. It's the kind of stop that happens thousands of times daily across America. Minor, procedural, unremarkable. His father, Kenneth, following behind in a separate vehicle, does what many parents would do. He pulls over at a distance behind the patrol car and waits, not interfering, not approaching, not creating a scene. Simply present. The deputy notices, and in that noticing, something shifts. The officer approaches Kenneth's vehicle not with curiosity but with command. The question isn't, "Can I help you?" but rather a series of statements framed as questions, each one designed to establish that Kenneth's presence is unwelcome. The deputy wants him to leave. Kenneth asks why. The deputy doesn't provide a legal justification, because at this moment there isn't one. Instead, he provides an institutional preference. Officers don't like when people pull in behind them during traffic stops. This is where the first critical decision point emerges. Kenneth has committed no crime. He hasn't interfered with the stop. He's parked at a reasonable distance on a public road. Under the First Amendment, he has the right to observe law enforcement conducting their duties in public spaces. Courts have consistently upheld this principle. The act of observation, even of recording, is protected activity. But the deputy doesn't acknowledge this right. Instead, he begins issuing directives: leave, go. You don't need to be here. Each statement delivered with increasing firmness, as if repetition creates legal authority where none exists. Kenneth responds with the reasonable question any citizen might ask: why must he leave? His son was following him. He's waiting to continue their journey together. He's not obstructing anything. The deputy's response reveals the core tension. You don't get paid to be behind us. It's a statement about roles, about who belongs where, about the proper ordering of public space. Officers pull people over, citizens comply and disperse. The presence of a witness, even a passive one, disrupts this familiar script. Kenneth's reply is equally telling. Do I not pay taxes? It's an appeal to citizenship, to shared ownership of public institutions and public spaces. But in this moment, those competing understandings of authority and rights cannot coexist peacefully. One will have to yield. The conversation deteriorates rapidly. The deputy accuses Kenneth of having an attitude. Kenneth points out that he simply asked a question. The deputy knocks on the window. Kenneth is accused of rolling it up. These are the micro-interactions where encounters are won and lost, not through legal arguments but through displays of dominance and resistance, each side interpreting the other's behavior as disrespectful or threatening. Another deputy arrives. The pressure intensifies. Kenneth is now being told he has seconds to leave. The framing has shifted from preference to ultimatum. But here's the critical detail. Even as they're demanding he leave, they haven't articulated a lawful order based on any legitimate law enforcement purpose. They haven't claimed he's obstructing the investigation. They haven't suggested his presence creates a safety concern that rises to the level of legal restriction. They simply want him gone because his presence is inconvenient. Kenneth eventually begins to comply. He starts moving his vehicle. This should be the de-escalation point, the moment where everyone gets what they want and the encounter ends without incident. Kenneth leaves, the traffic stop concludes, and life continues. But that's not what happens. Instead, as Kenneth's vehicle begins to move, something triggers a dramatically different response. Officers start shouting for him to stop, to stay, commands that directly contradict the orders they were just giving. The situation has flipped in an instant. Now they want him to freeze. Now his movement, which they demanded, has become the problem. This is the moment where legal justification becomes critical. If officers believed Kenneth was about to flee or posed some danger, they might have grounds to detain him. But the body camera footage reveals something else. Kenneth is moving his vehicle slowly, in the direction of departure, exactly as commanded. There's no sudden acceleration, no aggressive maneuver, no indication of flight. Yet multiple officers converge on his vehicle with weapons drawn. The commands become a wall of noise, contradictory, overlapping, impossible to parse in real time. Get out of the car. Stop. Don't move. Hands up. The cognitive overload alone makes compliance difficult. But for a 71-year-old man suddenly facing drawn weapons, the psychological impact is overwhelming. Kenneth stops the vehicle. He's not fleeing. He's frozen, trying to understand what's happening and how to survive it. But the officers are already in a different mode. They're no longer trying to secure compliance. They're executing a forced extraction. This is where the use of force pyramid comes into play. Law enforcement training teaches officers to use the minimum force necessary to achieve lawful objectives. The progression should be verbal commands, physical presence, control techniques, less lethal force, lethal force. Each step should be justified by resistance or threat at the previous level. But watch what happens here. Kenneth hasn't attacked anyone. He hasn't brandished a weapon. He hasn't made threatening movements. He's an elderly man in his vehicle, confused and frightened. Yet officers are already at the level of drawn weapons and immediate use of taser deployment. The justification will later be that he wasn't complying with commands. But which commands? The ones telling him to leave, or the ones telling him to stop? The ones shouting for him to exit the vehicle while he's still processing the weapons pointed at him? Compliance under these conditions isn't a simple binary. It requires time to process, time to act, time to demonstrate willingness. None of that time is provided. The first taser deployment happens quickly. Kenneth's body convulses with the electrical shock. He hasn't swung at anyone. He hasn't tried to drive away. He's simply not moving fast enough for officers who have already decided that force is necessary. And here's where the escalation becomes self-perpetuating. Once the taser is deployed, Kenneth's body responds involuntarily. He pulls away, not through intentional resistance, but through neurological reaction to pain and electricity coursing through his muscles. Officers interpret this reaction as active resistance, justifying additional force. Another taser deployment, then another. The body camera footage shows Kenneth crying out, trying to explain that he's attempting to comply, that he's hurt, that something is wrong. But the officers aren't listening. They're in enforcement mode, where every movement that isn't instant compliance is treated as defiance requiring escalation. Multiple angles reveal the physical toll. Kenneth is struck in the face. A taser probe embeds in his lip. He's bleeding. He's disoriented. Yet, officers continue issuing commands as if he's fully capable of executing complex instructions while being repeatedly shocked. His son, Nathan, can be heard in the background, his voice breaking between shock and restraint. He's watching his elderly father being tased repeatedly for the crime of waiting on a public road. He's told to stay back, to record if he wants, but to do nothing else. The message is clear. Witness if you must, but do not interfere with the exercise of police authority. This is the machinery of escalation in its purest form. A situation that required nothing more than a brief conversation has been transformed into a violent arrest, involving multiple uses of force against an elderly man who posed no threat. And at every step, the justification will be the same. He didn't comply fast enough. He didn't follow orders precisely enough. He forced our hand. But that narrative erases the crucial context. Officers created the crisis they then claimed to be managing. They demanded departure, then criminalized that departure. They issued contradictory commands, then punished confusion. They escalated to weapons without exhausting alternatives, then justified continued escalation based on reactions to pain they were inflicting. The legal threshold for use of force is objective reasonableness under the totality of circumstances. Would a reasonable officer in the same situation, with the same information, make the same decision? That's the standard. But reasonable compared to what? To other officers trained in the same aggressive tactics, operating under the same institutional assumptions about authority and compliance. Or reasonable compared to the constitutional rights of citizens and the basic human expectation that asking questions shouldn't result in being tased in the face. Kenneth Espinosa made a simple choice that day, to wait for his son. That choice should have been unremarkable, forgettable, the kind of minor decision that shapes an ordinary day without consequence. Instead, it became the trigger for an encounter that would leave him injured, traumatized, arrested, and fighting a legal battle that would eventually cost taxpayers over $1.5 million. The question isn't just what went wrong in this specific encounter. The question is how a system designed to protect and serve citizens has evolved to produce these outcomes with such regularity that they barely register as anomalies anymore. The violence is over in minutes, but the process of justifying it begins immediately. This is where the real institutional machinery reveals itself, not in the chaotic moments of confrontation, but in the careful reconstruction that follows. Body cameras capture the aftermath, and what they show is a system designed less to document truth than to manufacture a defensible narrative. Kenneth sits in the back of the patrol vehicle, his face bloodied, a taser probe embedded in his lip. He's in pain, disoriented, struggling to understand how waiting for his son became a criminal act. The officers, meanwhile, are already coordinating their stories, aligning their descriptions, building the foundation for whatever charges will come next. One officer speaks to his supervisor, explaining what happened. Listen carefully to the language. Kenneth refused to comply. He wouldn't get out of the vehicle. He was resisting when they tried to place him in the car. Each statement is technically true in the narrowest sense. Kenneth didn't move with the speed and precision officers demanded, but each statement also erases the context that makes those facts meaningful. There's no mention of the contradictory commands, no acknowledgement that Kenneth was attempting to leave when they suddenly ordered him to stop, no recognition that a 71-year-old man facing drawn weapons and experiencing taser shocks might not move with the agility of someone half his age. The narrative is streamlined, simplified, reduced to a familiar script. Suspect didn't comply. Force was necessary. Situation resolved. This is the critical function of police reports and inter-officer communication. They don't exist primarily to document what happened. They exist to establish a legally defensible version of what happened. And the officers involved understand this instinctively. They've been trained not just in tactics, but in the language of justification. The supervisor accepts the explanation without probing deeper. There's no interrogation of the decision-making process, no questioning of whether alternative approaches might have produced better outcomes. The institutional presumption is that officers acted appropriately unless proven otherwise. And proving otherwise requires overcoming layers of procedural protection, qualified immunity, union representation, and the inherent deference that courts and juries often show to split-second decisions made under pressure. But this wasn't a split-second decision. This was a series of choices, each one made with time to consider alternatives, each one pushing the encounter toward escalation rather than resolution. Consider the initial approach to Kenneth's vehicle. The deputy could have asked whether Kenneth needed assistance, whether there was a problem, whether he was waiting for the traffic stop to conclude so he and his son could continue together. Any of these approaches might have elicited cooperation without confrontation. Instead, the approach was territorial. You don't belong here. You need to leave. This space is under our control. That framing matters because it establishes the encounter as one of authority versus defiance, rather than public servants assisting citizens. Once that frame is set, every subsequent interaction is filtered through it. Kenneth's questions become challenges to authority. His hesitation becomes suspicious. His eventual compliance becomes too slow, too grudging, insufficiently deferential. The second decision point came when Kenneth began moving his vehicle. Officers could have let him go. They could have noted his information, followed up later if they believed some violation had occurred, or simply ended the encounter with mutual frustration but without violence. Instead, they chose to stop him mid-departure and escalate to weapons. What changed in those seconds? What new information emerged that transformed Kenneth from someone they wanted, gone into someone who needed to be forcibly extracted from his vehicle? The body camera provides no answer because there is no answer. The shift wasn't based on Kenneth's actions. It was based on the officer's growing frustration with someone who asked questions, who didn't immediately defer, who treated his right to be present as something worth defending. This is the pattern that repeats across countless encounters. Officers interpret assertion of rights as a form of resistance, and resistance, even purely verbal resistance, triggers enforcement responses that might otherwise be reserved for actual threats. The confusion between "you haven't obeyed fast enough" and "you pose a danger" is where constitutional policing breaks down. The taser deployments reveal this confusion starkly. Tasers were introduced as an alternative to lethal force, a way to subdue violent suspects without shooting them. But their deployment has expanded far beyond that original justification. Now they're used for non-compliance, for hesitation, for not moving quickly enough in response to commands. The threshold for use has dropped from preventing serious harm to ensuring immediate obedience. Kenneth experiences multiple taser cycles. Each one is recorded, each one justified in real time by officers claiming he's still resisting. But watch his movements. He's not fighting, he's not attacking. His body is responding to electricity in the ways human bodies inevitably respond. Jerking, pulling away, crying out. Officers trained in taser effects should recognize these reactions as involuntary, yet they treat them as intentional resistance requiring additional force. This creates a vicious cycle. The taser causes pain. Pain causes involuntary movement. Movement is interpreted as resistance. Resistance justifies more tasing. And so the cycle continues until Kenneth is either fully incapacitated or officers decide they've achieved sufficient control. The facial strike is particularly revealing. Taser probes are supposed to be aimed at large muscle groups, torso, thighs, areas where the electrical current can be most effective while minimizing risk to sensitive areas. The face is explicitly identified in most training protocols as a dangerous target zone due to risks of eye injury, airway complications, and other serious harm. Yet, Kenneth is struck in the face, with a probe embedding in his lip. The officer's later explanation suggests it was accidental, a result of Kenneth moving or falling during deployment. But that explanation raises its own questions. If the situation was so dynamic that officers couldn't control where taser probes struck, was it really appropriate to use tasers at all? If Kenneth was moving unpredictably, doesn't that suggest confusion and fear rather than aggressive resistance? The answer matters because it illuminates a broader problem in use of force doctrine. Officers are taught that they can use force to overcome resistance. But resistance is defined so broadly that it includes almost any behavior short of instant compliance. Moving slowly is resistance. Asking questions is resistance. Verbal objection is resistance. Even involuntary physical reactions to pain are resistance. Under this framework, virtually any use of force can be justified after the fact. The suspect resisted becomes an all-purpose explanation that shifts scrutiny from the officer's decision-making to the citizen's behavior. And because resistance can be retroactively identified in almost any interaction, the justification is nearly unfalsifiable. Kenneth's repeated statements that he's hurt, that he can't move properly, that he needs a moment, are ignored or treated as manipulation. Officers have been trained to distrust such claims, to view them as tactics suspects use to avoid compliance. And certainly, some suspects do use those tactics. But the training creates a presumption of dishonesty that makes it nearly impossible for citizens experiencing genuine distress to communicate that fact in ways officers will credit. This is particularly problematic with elderly citizens, people with disabilities, or anyone whose physical capabilities don't match officer expectations. When an officer commands, "Get out of the car," and expects immediate execution, they're often imagining a young, physically capable person moving quickly. When the actual person is 71 years old, possibly injured, definitely shocked and frightened, the timeline of reasonable compliance is different. But that difference isn't accommodated. The command is absolute. The timeline is immediate, and deviation is treated as defiance. Nathan watches all of this unfold. His presence is noteworthy because it illustrates another dimension of these encounters, the calculated decision about when to allow observation and when to suppress it. Officers tell Nathan to stay back, but don't arrest him for watching. Don't confiscate his phone. Don't physically prevent him from recording. Why? Because they understand that attempting to do so would create additional legal problems, would generate headlines about police preventing citizens from recording, would potentially violate clearly established First Amendment rights. So instead, they contain him through intimidation and implicit threat. Stay back. Don't interfere. Keep recording if you want, but understand that crossing this invisible line will result in your own arrest. It's a more sophisticated form of control than simply shutting down observation, but it serves the same function, ensuring that witnesses remain passive, that they document but don't disrupt, that they see the official version of events without being able to change the outcome. The institutional tolerance for observation is revealing in itself. These officers aren't trying to hide what they're doing. They believe their actions are defensible, that the body camera footage will vindicate their decisions, that any reasonable review will conclude they had no choice. That confidence isn't personal delusion. It's institutional experience. They've seen officers use similar or greater force in similar situations and face no meaningful consequences. They've been trained that these tactics are appropriate. They operate within a system that consistently validates aggressive enforcement over patient de-escalation. When Kenneth is finally secured and placed in the vehicle, the medical assessment begins. A supervisor or another officer is called to evaluate his injuries. This is part of standard protocol after taser deployment. Document any injuries, ensure medical attention if necessary, protect the department from liability claims. But watch how it unfolds. The focus isn't primarily on Kenneth's well-being. It's on documenting that appropriate procedures were followed. Kenneth continues to express pain, to point out the probe in his lip, to note that he's bleeding. The responses are bureaucratic. We'll get EMS to check you out, we'll document your injuries, you'll be seen at the jail. There's minimal engagement with his actual physical state, minimal concern for his comfort or dignity. He's become a problem to be processed, a liability to be managed, a citizen who caused trouble and is now experiencing the consequences. The threat of the restraint chair emerges in the aftermath. Officers warn Kenneth that if he continues to act like an idiot, their words, he'll be placed in the chair. The restraint chair is a controversial device used to immobilize combative suspects, strapping them into a seated position where they can be safely transported. Its use is supposed to be reserved for individuals who pose a serious threat to themselves or others, who are so violent or unpredictable that traditional handcuffs and vehicle transport are insufficient. Kenneth is 71 years old, has just been tased multiple times, is bleeding, and is showing no signs of violence. Yet he's being threatened with this most restrictive level of physical control. Why? Because he's not being sufficiently compliant with commands, not accepting his treatment without complaint, not displaying the level of submission officers expect after asserting their dominance. This threat serves multiple functions. It's a tool of behavioral control. Comply now or face worse consequences. It's a demonstration of the full range of force available to officers, and it's a message about who holds power in this interaction. Kenneth might think he has rights, might believe he was wronged, might feel justified in expressing pain or frustration. But the restraint chair reminder clarifies that all of those feelings are irrelevant in the face of institutional authority. The gap between Kenneth's experience and the official narrative is already vast and still widening. Kenneth believes he's been brutalized for doing nothing wrong. Officers believe they've lawfully arrested someone who refused commands and resisted their authority. Both versions will be documented. Both will be presented to supervisors, prosecutors, eventually to the public. But they're not equal. One version carries the weight of institutional authority, of sworn testimony, of professional expertise. The other is the complaint of someone who's been arrested, whose credibility is already compromised by the charges he faces. This is how the system manufactures consent for violence, not through conspiracy or cover-up, but through the routine operation of processes designed to validate official action. The body cameras that were supposed to create accountability instead provide raw material for justification. The reports that were supposed to document truth instead construct defensible narratives. The supervisory reviews that were supposed to catch misconduct instead confirm that policies were followed, boxes were checked, procedures were honored. And Kenneth, bleeding in the back of a patrol car, charged with crimes he didn't understand, facing the full weight of the criminal justice system, has already lost before the process even officially begins. The aftermath of Kenneth Espinosa's arrest extends far beyond the roadside encounter. What happens next reveals how institutions protect themselves, how accountability is distributed, and how the costs of excessive force are transferred from the officers who deployed it to the taxpayers who fund the system. This is where the true price of unchecked authority becomes visible, not just in dollars, though those matter, but in the erosion of public trust and the normalization of violence as a first response rather than a last resort. Kenneth faces charges. The exact nature follows a predictable pattern: resisting arrest, obstructing an officer, perhaps disorderly conduct. These are standard accusations deployed when an encounter goes wrong, and the department needs to justify its actions retroactively. If Kenneth is a criminal, if he broke the law, then the force used against him becomes easier to defend. The narrative shifts from "officers hurt an innocent man" to "officers arrested a suspect who refused to comply." But these charges reveal their own absurdity when examined closely. Resisting arrest requires that there be a lawful arrest in the first place. Officers can't simply decide to arrest someone, then charge them with resisting when they object. There must be probable cause for the underlying arrest, reasonable belief that a crime has been committed. What crime did Kenneth commit? Stopping on a public road, asking questions, waiting for his son? None of these are criminal acts. And if the initial detention was unlawful, then everything that follows becomes constitutionally suspect. The charges move forward initially. Kenneth must hire an attorney, begin building a defense, experience the grinding stress of criminal prosecution. This is itself a form of punishment, what's sometimes called "the process is the punishment." Even if charges are eventually dropped, Kenneth has already paid a price in time, money, anxiety, and reputation. Meanwhile, the civil case begins. Kenneth's attorney files a lawsuit alleging excessive force, unlawful arrest, violation of constitutional rights. This is a Section 1983 claim, the primary legal mechanism available to people harmed by police misconduct. But these cases face enormous obstacles. The first is qualified immunity, a judicial doctrine that shields officers from liability unless they violated clearly established constitutional rights. The specific conduct must have been previously declared unconstitutional in a prior case with nearly identical facts. Kenneth's case, however, may overcome qualified immunity because the use of force is so extreme. Courts have repeatedly held that tasing non-threatening, non-fleeing individuals who pose no safety risk violates the Fourth Amendment. The facial strike, the multiple deployments, the violence against an elderly man attempting to comply, all of this likely crosses into clearly established territory. The county's attorneys understand this. They review the body camera footage, the medical reports, the witness statements. They calculate the risk of trial, of letting a jury see Kenneth's injuries, of having officers cross-examined about their decisions. And they conclude what many municipal attorneys conclude: settlement is cheaper and safer than vindication. The settlement amount is staggering: $1.5 million. This is taxpayer money, paid to compensate Kenneth for his injuries and trauma. But notice who's paying. Not the officers who deployed the tasers, not the supervisors who approved the arrest, not the training academy that taught these tactics. The public pays. The same citizens who fund the police department are now funding the consequences of excessive force. This financial structure creates perverse incentives. Officers face no personal financial consequences for misconduct. Their salaries continue unaffected. Their pensions remain secure. The institutional shield is nearly absolute. This removes one of the most powerful deterrents to misconduct: personal liability. Compare this to almost any other profession. Doctors carry malpractice insurance and face financial consequences for negligence. Lawyers can be sued for malpractice, but police operate in a special category where the institution absorbs the costs of individual misconduct. Officers make risk calculations without bearing the full weight of those risks. The potential downside of patience feels more immediate and personal than the potential downside of excessive force, which is distributed across the system and paid by others. The officers involved were eventually fired. This is presented as accountability, as the system working. But examine what that firing actually means. It came after the incident became public, after the footage circulated, after the settlement was announced. It's reactive, not proactive. The department didn't identify a problem with these officers before they hurt Kenneth. Moreover, firing doesn't mean the end of a law enforcement career. Officers terminated from one department often find employment at another. There's no national database preventing this migration. No certification system that bars officers with sustained misconduct findings. They move from one jurisdiction to another, carrying their training and habits with them, potentially repeating the same patterns in new communities. The undersheriff's admission that several errors were made is telling in its vagueness. What errors? Who made them? What systems failed to catch those errors before they resulted in injury and massive liability? These questions go unanswered. The admission serves to demonstrate accountability without actually providing any. We acknowledge mistakes were made, lessons have been learned, we're moving forward. But what lessons, specifically? That officers shouldn't tase elderly men in the face. That's not a lesson requiring $1 million settlement to learn. It's basic human decency backed by explicit training protocols. That contradictory commands create dangerous situations. That's taught in every de-escalation course. That citizens have the right to observe police activity. That's established constitutional law. The real lesson that needs learning is more fundamental. That the current approach to policing treats authority as something absolute, compliance as something mandatory, and force as an appropriate response to anything less than instant obedience. Until that underlying philosophy changes, the specific tactical errors in individual cases become almost irrelevant. Kenneth's son Nathan carries his own trauma from the incident. He watched his elderly father being tased, saw blood on his face, heard him crying out in pain, and could do nothing but record. That's a profound powerlessness, the kind that reshapes how someone views authority and institutions. Multiply Nathan's experience by every person who's witnessed similar incidents. Multiply it by every family member who hears these stories and adjusts their relationship with law enforcement accordingly. The cumulative cost isn't just measured in settlement payments. It's measured in eroded trust, in fear replacing cooperation, in citizens viewing police as threats rather than protectors. The body camera system itself deserves scrutiny. It was implemented with promises of accountability, of creating objective records that would resolve disputes about police conduct. But Kenneth's case demonstrates the limitations. The cameras captured everything. The initial encounter, the escalation, the violence, the aftermath. They provided exactly the documentation reformers hoped for, and yet the initial institutional response was to process Kenneth through the criminal justice system, to defend the officer's actions, to treat the footage as evidence of justified force. This reveals that cameras alone don't create accountability. They create documentation, but documentation only matters if someone with authority reviews it critically and takes corrective action. When reviewers are predisposed to trust officer narratives, when standards for force are so permissive that almost anything can be justified, cameras simply record injustice without preventing it. The settlement announcement comes with no admission of wrongdoing. This is standard. The municipality pays but doesn't acknowledge that officers violated anyone's rights. It's framed as a business decision, not an admission that Kenneth was wronged. This allows the institution to pay the price while preserving the narrative that officers acted appropriately. But Kenneth knows what happened. His body carries the evidence. His medical records document the injuries. His bank account eventually receives compensation that, while substantial, doesn't erase the experience of being tased in the face by people entrusted with public safety. Money addresses financial consequences, but not the fundamental violation of dignity, of rights, of the basic expectation that asking questions shouldn't result in violence. The broader pattern is what matters most. Kenneth's case is not unique. It's representative of thousands of similar encounters where minor situations escalate to violence, where authority is asserted through force rather than earned through service, where citizens pay twice, once through taxes funding police departments, and again through settlements compensating victims. Every settlement represents a failure of systems supposed to prevent these outcomes. Training is supposed to teach de-escalation. Supervision is supposed to catch problematic patterns. Internal affairs is supposed to investigate complaints. Prosecutors are supposed to decline charges in unlawful arrests, and yet Kenneth's case made it through all of these supposed safeguards, only finding resolution after significant public pressure and legal expenditure. The question isn't whether this incident was handled correctly after the fact. The question is why it took a viral video, a lawsuit, extensive media coverage, and $1.5 million to achieve what should have happened immediately. Recognition that tasing an elderly man for asking questions is unacceptable. The answer lies in understanding that these aren't system failures. They're system features. The institution is designed to defer to officer authority, to treat force as presumptively justified, to make accountability difficult and expensive. Reform efforts that don't address these foundational structures will continue producing the same outcomes with different actors. Kenneth Espinosa wanted to wait for his son. That simple paternal instinct triggered events that left him injured, arrested, and eventually compensated but also traumatized and disillusioned. His case entered the permanent record of American policing, another data point in the ongoing conversation about excessive force, another reason for citizens to fear rather than trust the officers patrolling their communities. The taxpayers absorbed the financial cost without input. They funded both the department that employed these officers and the settlement that compensated their victim. They received neither improved safety nor enhanced service. And Kenneth carries the permanent reminder of what happens when authority meets resistance, when power decides that obedience is more important than rights, when law enforcement focuses more on control than service. His story joins countless others, a testament to the ordinary violence embedded in systems that claim to protect us. The Bodycam footage remains, a permanent record of choices made and consequences inflicted. It documents not just what happened to one man on one winter day, but what continues to happen when authority becomes untethered from accountability, when force becomes the default response to questions, when institutions protect themselves at the expense of citizens they supposedly serve. This is the true cost of unchecked authority, not just the settlements paid and injuries inflicted, but the slow corrosion of trust that makes democratic policing impossible. Until the lessons become structural rather than superficial, the cases will continue, the settlements will mount, and citizens will continue learning that their rights exist in theory, but often vanish in practice when power decides otherwise.